Good evening, everyone. I call the special meeting of the Victoria City Council to order. For special meetings, we get right down to business. So with that, let's dive right into our agenda. We have one item on our agenda this evening, and that is to review Ordinance 414, our predatory offender residence restrictions, and conduct a public hearing. Before we hold the public meeting, I want to take a moment to go through some of the housekeeping items. First, welcome to everyone here in the council chambers and to all of you who are watching. And thanks for taking the time from your day to be with us. There is no presentation from staff this evening, so we're going to move directly into taking public comment. We want to make sure that anyone who's wishing to address council this evening will have an opportunity to do so. So to that end, if you wish to speak and haven't already pre-registered, we ask that you please fill out the form that can be found on the side table right here in the council chambers, which is right over there, and hand that form off to a staff member. We'll be calling speakers to the podium in the order that they were received. And once called to the podium, please state your name and address for the record before you start your comments. Each speaker will have 5 minutes to address council. We respectfully ask that points that have already been made not be repeated. Our city clerk will be keeping time. When you hear the ringtone, we respectfully ask that you wrap up your thoughts so we can recognize the next speaker. The focus of the meeting this evening is on the city's Predatory Offender Residence Restrictions Ordinance, which was adopted in 2017. We heard from many of you during and after the recent community notification meeting that the City Council should review and make changes to this ordinance. This evening, we're looking to hear from our residents, our community, on which specific changes you'd like us to consider. Once everyone has had the opportunity to speak, we will close the public hearing. It will then be council's time to discuss and provide direction to staff on next steps. Just a note, our regular city attorney couldn't be with us this evening, so we welcome Mr. Dave Anderson, who is with us this evening to provide legal counsel to us. And Sheriff Camerood will be sneaking into the meeting here when he is available and sitting at the dais just to make sure we have plenty of room for our residents out in the audience, and he will take questions if needed. And now with that, I would like to open up the public hearing. Our first registered presenters are Sherry Schultz, along with Laura Maurer and Brandon Shimke. Please make your way up to the podium. These three are presenting as a group. We're allocating them 15 minutes. Sherry, Laura, and Brandon, we ask that you please state your respective names and addresses prior to speaking. Clerk Patnode will start the time when you hear the ringtone, and please wrap up your comments at that time. Thank you so much. Welcome. Go ahead, Sherry.
Sherry Schultz, Woods Drive, Victoria, Minnesota. Mayor McMillan, Council, Attorney Anderson, and City Manager Hardy. It is with great conviction that we, the community members of Victoria, are proposing the following residence restriction amendments to Ordinance 414. As we know from countless research studies, and in Minnesota and nationwide, predatory offenses committed to children have an ongoing impact on the lives of those children and ultimately perpetuate the cycle of abuse in victims indefinitely. A failed placement is not merely a statistic we reference. It is fact, an insurance policy that predatory offenses will continue. A proper placement and a commitment to protecting future victims is in fact synonymous with the rehabilitation we all hope for. It is today at this hearing the single greatest thing we can affect to improve recidivism rates and protect our children and their future. Before I review some background on residency restrictions in Minnesota, I want to make one statement that we can never forget about. Over the last 30 days, we have focused countless hours and all our energy on the placement of Matthew Van Hekke in our community. Tonight, however, we are focusing on the future and preventing these horrific acts from ever happening to children again. While the names and identities of his victims are rightfully unknown to us, we want you to know these amendments are for you. We are with you. I'd like to review briefly an overview of the Minnesota residency restrictions that exist more broadly. In Minnesota, 92 cities have residency restrictions for sexual offenders. 31 of these cities are in the Twin Cities metro area. 7 of these cities are in our immediate vicinity. Cities in our immediate vicinity include Deep Haven, Excelsior, Greenwood, Independence, Orono, Shorewood, and Tonka Bay. Many of their ordinances contain identical language, but have some modest differences. Our proposal includes clauses from the current Victoria City Ordinance, along with Deep Haven's Ordinance from January of 2017. These cities have also conducted their workshops, and so we feel pretty good about what we're referencing. The amendments will include things like increased buffer zones for level 3 predatory offenders, the application of Deep Haven's clauses as to level 1 and 2 predatory offenders when offenders committed crimes against minors. And we've generally applied Deep Haven's exception clause and ultimately the application of Deep Haven's purpose clause. So I'm going to start by reviewing the purpose clause, and then I'm going to advance slides for Laura, who's going to take the podium next. So the purpose clause that we are recommending, purpose, it is the intent of this ordinance to serve the city's compelling interest to promote, protect, and improve the health, safety, and welfare of the citizens of the city by creating areas around locations where children regularly congregate in concentrated numbers, wherein certain predatory offenders are prohibited from establishing permanent residence.
My name is Laura Maurer, Wood Circle. Thank you all for having us here. Before I dive into what we'll call the redlining version that will, you can skip to the slides for redlining, I want to give a little bit of background of where all of this is coming from, right? So we did case law research ourselves, and the case law precedent means that we fall within the 8th Circuit. And so the 8th Circuit is the court that the Minnesota District Court in the city of Apple Valley had to withhold the holdings in Miller and Weems. So you'll hear me refer to Miller and Weems throughout today's discussion as well. And again, Miller and Weems is case law precedent that the District Court of Minnesota acknowledges and has to uphold as well. And with that said, I just encourage City Council to review our case law precedent and understand that this is the law here in Minnesota, meaning that this is what we are able to uphold for constitutional claims as well. So the proposed ordinance amendment that you're looking at is designed to reduce the likelihood of reoffense by limiting offenders' temptation and opportunity to commit a new crime. So what that really means is when you look at the definitions, we did add information from the Deep Haven Ordinance, and this is really important to protecting our children. So when you look at number 1 and number 2, these are new clauses to our ordinance to protect our children from predatory offenders who are actually committing crimes against minors. So when you look at the number 2, it's defining what those crimes are. They're all crimes against children, just in different degrees, 1st degree, 2nd degree, and so forth. When we talk about what this is doing for our children, it's going to protect them, is that we're adding these sex offenders in here from the Deep Haven Ordinance, just like Sherry mentioned. They've conducted all their workshops, they've had all their legal research as well, and they know that there is a rational purpose and a legitimate purpose for us to do something like this. When you look at bullet number 3, we are actually keeping in what Victoria currently has, and that's for the level 3 sexual predator. So we certainly want to maintain that part of our ordinance. We want to protect our children from the most dangerous offenders, regardless if their previous crime was against a minor or not. So again, number 3 is for somebody who's been leveled by the state of Minnesota to be the most likely to reoffend compared to a level 1 and a level 2. You'll see also with the additions, we have added residential childcare facilities, neighborhood pool, so there's some other additional terms we'd like you to take under consideration. And again, what the courts are going to look at is there a legitimate purpose behind this, and is this going to cause, they're going to look to make sure that the legitimate purpose is there because this is where children congregate, and these are areas that they do. So again, the City of Victoria has a legitimate interest in protecting children from the most dangerous offenders, and residency restrictions designed to reduce the proximity between the most dangerous offender and locations frequented by children is within rational policy options to help protect the health and welfare of children. And that line is taken from Weems, and that is a case I would encourage City Council to speak with the City Attorney about as well. When we look at the designated buffer zones then, what the additions are doing is going to parse out the 2 types of offenders. So we have, for the predatory offender recommendation, is to look at the level 1 and the level 2 who are actually committing crimes against children. And so we've added that language to be 1,600 feet for each of the buffered zone areas, from a public school to licensed care facility and so forth. As stated in Miller, again, which is our case law precedent, there is no constitutional claim for the right to live anywhere. That claim is not a constitutional claim for these sexual predators. And instead, what the courts are going to look at is they're going to use a rational purpose standard of review, excuse me, and not a strict scrutiny type of review. So with 8th Circuit precedent, again, Miller held that the Iowa statutes and guidelines, where the residency restriction imposed by the Iowa statute was categorical and only applying to sex offenders who had victimized minors, was constitutional. So again, I'd ask you to look at Miller with your city attorney to understand that case law. So we will be following, again, the Deep Haven approach with that aspect of the #1 buffer zone recommendation. For the second recommended buffer zone, it's essentially what we've had today in Victoria for the level 3. We're just increasing that amount of feet to 2,000. And as we learned, where the sheriff is measuring from the school, it's not where everyone thought. We thought the measurement from a school would be where that park is at from Victoria Elementary, and that's not the case. So we do need to protect our children when they're walking home from school, when they're at parks, from the most dangerous type of offender, or level 3. So when I actually start closing on that level 3 piece, the city of Victoria can look to Weems as well when you're speaking with the city attorney, which states their legislature undoubtedly had a legitimate interest in protecting children from the most dangerous sex offenders. I also want to just have a brief discussion about, as a reminder, the majority of residency restriction laws that are found to be constitutional are usually around 1,000 to 2,500 feet. So being 2,000 isn't anything out of the ordinary. Victoria is mainly residential, and projected growth in new residential communities is on the rise. And although Apple Valley was sued by sex offenders, their injunction was denied by the Minnesota District Court September 16 of 2020. It was denied even when the Does claimed 90% of the residential properties within the city was off limits. And that's again because the Minnesota District Court has to follow the case law precedent of Miller and Weems. The city of Apple Valley did settle, but not due to constitutional issues. And in Weems, the Arkansas statute prohibited level 3 and level 4 sex offenders from residing within 2,000 feet of a school or a daycare center. And the Arkansas statute challenge in Weems was in some respect broader, but in other respects narrower than the one that they reviewed in Iowa with Miller. I'll let Sherry continue.
There are exceptions to these buffers that we acknowledge, but are recommending critical amendments to further reduce recidivism based on 4 amended exceptions. The first, as outlined, the designated predatory offender or designated level 3 predatory offender has lawfully and continuously established permanent residence. So continuously established permanent residence. The second and third are additions that we are suggesting. The designated predatory offender or designated level 3 predatory offender was a minor when he or she committed the offense and was not convicted as an adult, so there is an exemption unless the offender's residence is the same residence that a previous victim resides. So if you committed this and you are to return to the very home with someone who you committed the offense to, that would not be an exception. The designated predatory offender or the designated level 3 predatory offender is a minor unless the offender's residence is the same residence that a previous victim resides. So in 2 cases, whether tried as an adult or not, you do not return to the home if the victim lives there. Unfortunate, but often you find that. So we are putting that into our amendment recommendations. And then finally, if that residence is a facility that is owned or leased by the Minnesota Department of Corrections, such as a halfway home. So that would also be.
Good evening. Brandon Shimke, 9045 Lakeside Drive. Talk quickly about a subsection, a new addition about prohibited activity, that it would be unlawful for any designated offender or designated level 3 predatory offender to participate in a holiday event involving children under 18 years of age, such as distributing candy or other items to children on or preceding Halloween, wearing a Santa Claus costume on or preceding Christmas, or wearing an Easter Bunny costume on or preceding Easter. Holiday events in which the offender is the parent or guardian of the children involved and no non-familial children are present are exempt from this subsection. Madam Mayor, council members, and city officials, in closing tonight, we are not here to protect the 700 plus children from the woods of Wasserman Lake area. We're here to protect every single child of Victoria. While offender sentences dissipate over a far too short period of time, their actions permanently alter the life of their victims. It's up to us at a city level to be the first line of defense for our children when the DOC's approach is to openly thrust this burden onto the community at large. Tonight, it is our sole intent and purpose for this ordinance amendment proposal to provide protection to the children of Victoria. More specifically, it is imperative that the city and the city attorney take action to prevent another child sexual predator or level 3 sexual predator from being able to reside within close proximity to schools, child care facilities, and other defined locations where children generally congregate, in order to prevent the opportunity and temptation. In order to prevent the opportunity and temptation of a sexual predator reoffending against the children of our great city. Thank you.
Thank you.
Thank you.
All right. Other people who would like to speak to this ordinance, please approach the podium and state your name and address for our record. Hi, welcome.
Hi, I'm Lacey Scott Hennon at 9152 Wasserman, and I support this request.
Thank you.
Thank you.
Katie Harper, Woods Drive. I 100% support this request.
Thank you.
Kate Prokop, Woods Drive, 2447. I support this request as well.
Thank you.
Eric Herbst, 2447 Woods Drive. I also support our team wholeheartedly. Thank you.
Thank you.
Molly Faber, 9190 Lakeside Drive, and I'm with these guys completely.
Catherine Beck, 2631 Woods Drive. I 100% support, 1,000,000% support this group. I do want to let council know that our current resident, who is a level 3, he manages to drive past our pool. That is the route that the family and he have chosen to leave our community, which has left our children vulnerable when they're outside. So families are feeling really restricted on letting their children play. And after a year and a half of being at home and having that be your safe place, right? We've had COVID, we've had a year where we've said, stay home, that's where it's safe. Well, now we've brought a monster into a community that no longer feels safe. And right now is a time where he's ankle monitored and he has to give his schedule. But what happens in 90 days, 6 months, a year from now, where he's not as restricted? That is more of a concern than it is right now, as we of the neighborhoods are all watching and we're as hawks. But when things slows down a little bit, that's where the concern is. That really is what's going to happen when he's not being watched and he all of a sudden does something. So we want to prevent this from happening anywhere else. Am I not close enough?
No,
Sorry.
hang on just a second. Alyssa, can you turn the podium mic down a little bit? Thank you.
There you go. So we definitely want to prevent this from happening again. Obviously, we have our current situation that we're working on hopefully changing, but we have another situation that's happened in Mayor where the individual is being placed there and has been able to, 45 years in prison, or be able to take a 90-day sentence and be able to be under watch for 20 some years, right? Take half the sentence. And these types of crimes shouldn't be able to take residence in communities, especially with children. So we want to make sure we protect against that. So thank you.
Thank you.
We did not plan this, but I was doing some research, and recidivism in the United States is about just under 50%, where in the Netherlands, where they are required to continue monitoring, it's less than 10%. So if monitoring were to continue, the probability of another child being hurt is diminished greatly.
Thank you.
Thank you.
This is a very emotional event for me.
We understand. Can
My
you
name-
state your
My
name?
name is Marla Westfield. I've lived in Victoria for 30 years. My address is 1180 Lilac Circle. We need to be better. As a survivor of abuse, we need to protect our children. This may or may not be enough. Other communities have set limits, density limits, on the number of offenders that are eligible to be in their community. Right now we have 3, 1 from Florida, 2 from Minnesota, in a community of 10,000. What density will we allow? Please consider that in addition to the limits on places children congregate. Thank you.
Thank you.
Thank you.
Hi, my name is Mitch Kluska, 9094 Lakeside Drive, and I cast my support. Thank you.
Thank you.
Michael Harper, Woods Drive, fully supportive of our group and of this request. Thank you.
Thank you.
My name is Michael Olson, 1699 Steiger Lake Lane, and I'm here to support these amendments and to prevent this from happening to any child in our community. Thank you.
Thank you. Sure, come on back.
Catherine Beck, 2631 Woods Drive. I love the courage that you have to speak up, because through this, most people shut it down, right? Where they were told, don't, you're fine, don't talk about it. Very few victims actually have the courage to speak up. 1 in 3 girls are sexually assaulted before the age of 18, and the number used to be 1 in 20 boys, but those numbers have gone up to 1 in 4. So I want to put that out there, because sexual abuse in children is rising, and if we don't protect them, it does have lifelong effects. It is PTSD. One of my daughter's friends, she was abused a couple of years ago, and she's now 12. And it was by a friend's dad, which I know people say it does happen from people, I'm going to fight tears, sorry. But she now has night terrors. She has PTSD. She goes through these emotional roller coasters. And I can't imagine the victims of our local predators, what they must be facing, because they didn't get much notice, right? It was pretty much, here you go. And Cameroon didn't even have time to go sit down with the families. That's how quick this process happened. And I think it's really important that we do what we can as a community to protect them, but it starts here, and then our change can go at a greater level. So I want you to know that this committee is committed to not only making change here, but we want to make change at the state level and protect all 1.4 million children. So thank you.
Thank you.
Thank you.
Is there anyone else who would like to speak to this item? Anyone else? Sherry?
So I've been asked a lot over the last 30 days, why? Why is it important to you? Why? And I've spent a lot of time thinking about this from both angles, and I think, my community can reflect many different sides of this. What it's like if it happens to you in your own home, or has happened to a loved one in your family. What does it feel like to have a predatory offender move in next to you? And what drives you to prevent either from happening? And I want council to understand It is with great pain that I see both sides. The reality of what our level 3 sex offender has done provokes many questions that the DOC and other agencies, our hope is, will answer. The likelihood that something occurred to him is high. We know this. Those offended often reoffend. Victims victimize others. And so we have amongst us the understanding of both sides. And I want counsel, I want our attorneys to understand. We are where we are tonight, which is to stop things from moving forward from the placement that we observed happen. We understand that's not where it began. It didn't begin there for him, most likely. But our plea out there to the victims and the support that they deserve is equally as important. And our work, while it starts here tonight to consider placements, it will go on with the DOC to stem this, which does mean an evaluation in homes, in families, and supporting therapeutic rehabilitation inside a home and for places where victims are living with this. You know, and I urge you to understand this is very deep, and I know you do and can understand that. We're here to control one side of the funnel, right? The unfortunate side, when it's too late. Our hope is that we can work with the DOC together to stop a different side of the funnel. And our hope is that we get to do that. Thank you.
Thank you.
Thank you so much.
Is there anyone else who would like to speak to this item? Last call. Anyone else who'd like to speak to this item?
I guess, do you have any questions for us from everything that you heard regarding the ordinance modifications that we'd like?
You know, at this time, I don't think so, but I trust you will stay put here while council discusses, and then if need be, we can call you to the podium.
Okay.
Okay?
Are we just going to discuss between us, or are we going to discuss with them?
Well, if there's a reason to get some feedback from the audience, we will certainly do it, but that will be council's time to talk.
Okay.
Okay.
These rules.
All right. With that, I'm going to close the public hearing, and I need a motion to do that. So can I have a motion to close the public hearing?
Motion to close public hearing.
Thank you. Can I get, thank you. All in favor?
Aye.
Aye. Now I'd like to open the floor for the council to discuss and provide direction to staff. So council, thoughts, comments, questions? We have, I mentioned Mr. Dave Anderson is here to answer some legal questions for us.
I have a time.
All right. Councilmember Black, let's start with you.
Okay. I went through everything that you guys wrote, and thank you so much for that.
Yeah, can I thank you for that? I thank you for doing so much work. We so
Yes.
appreciate it, and it has been really helpful to help inform our thought process here.
One of the questions that I had was, you separated levels 1 and 2 and 3. And I wasn't quite sure how we could do that when level 1 and 2 is not public information. So how would we do that?
Ms. Mauer-White, will you please approach the podium and go ahead and state your name again for the record? Thank you.
So this is Laura Mauer, Woods Circle in Victoria. So without public notification, so level 1 and level 2 is part of the registry, right? So what will happen is they will always be notifying the law enforcement. So what will happen is law enforcement will see where that placement's gonna be, and they'll also keep records of those residents' registration. And so long as the law enforcement is always that central base of knowledge, this would work.
Okay, I just wanted to make sure of that.
I had a question on that. Sorry to cut you off. Just, I thought I heard at the town meeting a month ago, whenever that was, that if you're a level 3 and you follow certain guidelines, you could be moved down to a level 2.
Correct.
I don't know. I thought I heard that. I'm not sure if but how would that play into that? If you were at one level and you were following protocol in your rehabilitation and you were moved down to a lower level?
That's correct. So to answer your first question, they can level down. There will be a risk assessment if the offender requests that. It might be 3 years or so. If they level down, then that would apply to the level 1, level 2 restrictions that we're also proposing. If that level 3 originally committed crimes against a child. If that level 3 did not commit crimes against a child and they moved down to level 1 or level 2, then that would not fall within our definition.
And last question. I know it's on the same topic, so
Right.
I'm sorry I'm cutting you
That's
off.
okay. Fine.
Are you opposed to having one stricter level of
No, absolutely not. We would actually encourage to just keep everything 2,000 feet for level 1, 2, and 3. But what makes this different is that we have the severability clause. So what that means is you can take clauses out if for whatever reason when the court looks at something to apply a certain set of facts, they can remove that without finding the entire ordinance unconstitutional. So it's just a recommended safeguard that you could talk to the city attorney about. Yep.
Okay.
Thank you.
Yep,
The
thank
other
you.
question I had,
Councilmember Black.
the other question one of the other questions, on the prohibited section under number 2, you have several listed. I was wondering if we were able to add shall not be placed adjacent to the home of a minor or a vulnerable adult. Because 2,000 feet, you could be right outside that and they could move in and then the children would be right next door. So I'm wondering if we should be adding that and if we can add that.
It's definitely something I would ask the city attorney. Absolutely, yep.
Okay. And then, what was the other? Then the exceptions. When we talk about 2 and 3 with the minors, actually, they've changed that so that minors are not classified. They're not given levels 1, 2, or 3. So I don't even know that.
So a minor may not, if they change that, but what might happen is that minor is released at like an 18, 19-year-old, right? So what will happen is if they're 18 or 19, even though they were convicted of a crime as a minor and held as a minor, they may not be released from prison until they're 18 or 19. So that exception then is placed that if they were convicted as a minor, it gives them a little bit more, or gives our ordinance more flexibility so it's not too restrictive on that minor. I'm going to pause because I want to make sure that makes sense.
Okay, designated predator.
So what will happen is if they're 18 or 19, they may have that leveling happen because they're an adult leaving
Okay, so
prison.
you're thinking that they committed the crime as a minor, they come out as an adult.
Yep.
You're saying that they would probably be given a level at that point?
Potentially. I mean,
Okay.
it doesn't hurt to assume that they might get leveled.
Okay. And then maybe the last thing, the prohibited activity.
Yep.
In the holiday event. Actually, I would like that to say any event. And with the Halloween costumes and Santa Claus as an example, but any disguise or costume.
It'd be something you'd want to ask the law firm about. We're for that, certainly to make anything more restrictive. I just would
The reason I asked is because when we were going through that whole lawsuit several years back, they just nitpicked the words. And I'm afraid that if we don't say any, and any type of disguise or costume or any type of an event that brings children, that they could say, well, you didn't say birthdays, so I just wanted to
and
make
maybe
sure.
you add instead of any, events that are, somehow you would redefine it for children, right? So you'd have to make sure that child clause is in there.
Yeah. I think we understand the intent here.
That would be, yeah.
Well, we understand the intent, but I'd like it to be
Right.
specific.
And Deep Haven and Tonka Bay are the ones who actually have that clause, so if you want to.
Deep Haven and Tonka Bay.
Tonka Bay, yep.
Yeah. And then any events, holiday, but I put any, events in which the offender is the parent or guardian of the children involved and no non-familiar children are present are exempt from this subsection. I would probably, unless court ordered, maybe. Does that make sense, or?
I think I would lean
I
to
think
the city attorney on that one. But
I don't know,
Yeah.
well, not to
Councilmember Black?
let them come in, but.
Yeah.
I think we understand what your intent is here. I think we don't want to wordsmith this in this council meeting, but we understand what your intent is. So we've captured that, staff has captured that so that we can work with our attorney on what those words need to be.
Okay.
Mayor McMillan?
Councilmember
Do you
Abe.
understand what I'm saying? Or do you agree with that, or?
Councilmember Hebert?
Be fine with that, yes.
Regarding the same section around the holiday, I noticed that they were all Christian holidays. Okay, well, I was just curious to know. I mean, I'm sure there are non-Christians living here, and
Right.
You're a resident Jewish person, so I will, Sherry Schultz, Woods Drive.
Please.
Again, we pulled from Deep Haven and Tonka Bay as precedents, like we looked at what had been approved, and, there are those holidays that fall outside of, you might have a Diwali festival, you might have, and I agree with you. And so that was some dialogue we had hoped to have with the attorney as well, because there are festivals for other religions and ethnicities that do wear masks or celebrate in a different way. So I would agree, but for the purposes of tonight, we wanted to give you something that we pointed to that had already been initiated. So I would agree that there are other holidays or other celebrations that are non-Christian that I believe as well should be included. So you're right.
thank you. Yeah, thank you.
Right. Thank you. Councilmember Black, anything else?
Not at this point.
Councilmember Hebert?
I did have one other, the part where at-risk adults. I guess this is just an open question. Why wouldn't we have, if we decide to go down this path, why wouldn't we include the same language for children and at-risk adults?
I would certainly agree to pull in the vulnerable adult language and work with the city attorney on that too. Sherry led to this. We were trying to pull clauses that have already been established by either another city or through case law. Right. And we, highly encourage to work off of that and expand it as needed. Okay.
Yeah, I would like all that, including vulnerable adults as well.
I think there's some other vulnerable populations we should include as well, certainly. Councilmember Hebert, anything else at this point?
Not at this point.
Councilmember Gunderson, anything?
Yeah, Dana or Mr. Anderson, do we know what Apple Valley settled for in terms of their, how much?
70,000.
70,000?
Mm-hmm.
15 went to the offenders, the rest was attorney fees.
Okay.
And the insurance claim covered most of it.
And the more restrictive we get, how much more risk do we move up on the likelihood of being sued in terms of restrictions? Based on the MNSOP program and the ping pong ball that's been in the courts, the reason that this was in front of the Planning Commission when I served was because it was deemed, the MNSOP program was deemed unconstitutional. So we were putting in safeguards or attempting to put in safeguards to deal with this exact situation. Then it was deemed constitutional. Then now it's back as of January, being talked about as unconstitutional again and picking up steam again. So I want to know, we make any changes, where are we likely to get hit and said, well, you can't do that anyway. So what we'd gone through was unnecessary and is going to cost us in the long run.
Mr. Anderson, can you comment, please?
Thank you, Mayor. Councilmember Gunderson, that's a good question. What I can say about more restrictive, less restrictive ordinances for residency restrictions is that generally speaking, Whenever you're in sort of an area that's either controversial or there are questions about not only constitutionality, which is one concern, albeit not the biggest concern with these ordinances in terms of their legality, but the more restrictive you are, the bigger the target may be on your back as a city for certain groups that target cities and for lawsuits and that kind of a thing. Now, what I can add is, to my knowledge, and I don't know the ins and outs of the Apple Valley case and why they settled. And Weems and Miller, those cases are cases, and the Eighth Circuit is good precedent in Minnesota, of course. And those deal with federal law and constitutionality. The issue that I assume that case settled for, the reason that case likely settled, and why other ordinances like this have been overturned by district courts in Minnesota is actually a state law issue. And there's no appellate court decision that makes that binding precedent, although it is compelling in regard to the decisions that those district courts have made, because the issue is preemption. The state Minnesota sex offender program, as you said, was deemed unconstitutional years ago, and so a number of cities enacted these ordinances. There's been no involvement by the legislature since then to provide cities with express authority to actually adopt residency restrictions. And so there's still, in my view, a gap in a city's ability to do so. Now, in that regard, it doesn't matter how restrictive you are or how restrictive you aren't. It's really any sort of residency restriction is questionable for that reason. And so I think that answers your question. But the bottom line is, as your attorney, I'm less concerned about the constitutionality of these ordinances and more concerned about the state law issue, which is preemption, because that to me is a more compelling issue and a more significant issue with regard to the cases that have actually been overturned and the ordinances that have been deemed unlawful.
So legislators from both parties have supported the state continuing to fight for the MNSOP program on a state level. If a change is made to the state level law, does that mean the court cases have to start all over again at basically zero because they've changed the program at the state level on a constitutionality question? So that would affect us, because then if we're acting under the new state law, we would get drawn into whatever lawsuits come up from there.
Yeah, I mean, I think I know where that question's going. I mean, if the legislator expressly put authority into the state law, into statute that says cities have the right to effectively enact ordinances that control where offenders reside, then there'd be no question. I mean, it would be your express authority as a city to do that. The issue is that has never happened. Nothing has happened with the sex offender program since it was deemed unconstitutional in terms of legislatively. And, to date, we don't have anything in state law that gives cities that express right. There is, as cities, you do have general authority in 412 and in other chapters of state law that give you the right to, enact ordinances that are to the health, safety, and welfare of your citizens. And that's certainly part of the authority that we would rely on in defending such an ordinance. But the issue is conflict preemption and field preemption. And both of those are big questions as all cities in Minnesota deal with these ordinances.
I mean, no matter what we do, if the state decides it's going to do something, it's going to affect whatever decision we make now. Is that
potentially, depending on what they do? Yeah. I mean, I guess I'm not sure what.
I just want to make it. Maybe if I'm not, I want to make it clear that we're going to do what's in the best interest of Victoria, but there are outside forces, mainly at the legislative level, that could have been done before this and can be done after this to make it better.
Yeah.
Right?
To provide cities with this authority or stronger authority, absolutely.
Okay.
Yeah.
Okay. Ms. Maurer, please.
I'm glad you brought up the preemption, and actually I have a question for you then. So the way I read Dayton, so Dayton was a case where they applied the Minnesota statute saying that state law is preempting that city ordinance of Dayton, right? So because the state law spelled out A, B, and C, the Dayton ordinance was held void in that circumstance. So what that means is that the Minnesota statute is actually talking about placement by the DOC. So in that case, it was a civilly committed person who was actually gone through the whole standards of process and released from civil commitment. There's 3 of them. So in the statute, it said, yep, the DOC can decide where that person is going to be placed, regardless of what the city ordinance is going to say. So that was where the preemption happened. It was because it was a placement from civil commitment into a community. It wasn't, I'm just a random level 3 coming from Florida finding preemption in the state law. So just keep that in mind, that preemption shouldn't scare you. It is something that could happen, but it's not necessarily applied across every scenario. The other set of circumstances is there might be another part of the Minnesota statute that we'll work with Julia Coleman on, but I won't speak to that right now because it's not necessarily important right now. But it's great that you're here to talk about that.
Yeah, thank you.
Thank you.
Councilmember Gunderson, anything else? I have a couple of questions. One of the things that we had talked about was that by enacting an ordinance like this, we would be, in effect, establishing another zone. Like it's a zoning law consideration. As we go forward and we think about what this ordinance is and kind of knowing that it's following under maybe some zoning rules and laws, what should we know about that?
That's a good question. Especially most recently, there was a City of Waconia case that came down just a couple weeks back that really broadened the applicability of zoning provisions and what cities need to consider zoning provisions. It's really any, well, I don't want to get into the weeds, but it does increase the likelihood that a court would say what you're doing here is effectively enacting a zoning ordinance, which means you're subject to Chapter 462, which requires public hearings. You're having one tonight. So I don't see any issue with your inability to adopt an ordinance like this for that reason, because you're following that requirement here tonight. Doesn't mean you have to adopt the ordinance tonight, and I don't think that's, of course, on the table. But in the future, you would have checked off that box. But it also can affect applying these sorts of ordinances retroactively in the zoning context. There are what are called legal nonconformities, and that means if you have established a use in property that was legal at the time that you established it, if and when the city changes its zoning ordinance and says that's illegal, you have the right to continue that. I don't think that would cause any issues in this regard, at least with respect to the proposed ordinance changes, because there still is that language in there that says anybody that's established residence on or before the effective date of this ordinance would be able to remain at their residence. So, good question, but I think that's the answer that you're seeking, and I hopefully I answered it.
Okay.
That's really the zoning implication, if you will, in regard to these sorts of ordinances.
Okay. The other question that I had is around when these folks are released from prison and they are given this set of things they have to follow, and so many of these things are covered by those restrictions. So for instance, we were told that the level 3 sex offender that is living in Victoria couldn't dress up as Santa Claus, couldn't give out Halloween candy and some of those things as a condition of release. Is there any concern about including that in an ordinance?
Not on its face. Cities, like I said before, have a right to enact ordinances that may be consistent with state requirements. They may be stricter in certain cases. They may be less strict. But I don't want to downplay the importance of the preemption issue, because the point that Judge Robner made in that Dayton case was that, at least this was the judge's opinion, that state law was intended to totally occupy the field that decides how sex offenders are treated after they get out and where they go and how they go there and where they can be. And because of that field preemption, it takes the city's, according to this judge, it takes the city's right to dictate any of those things out of the city's hands. And again, that's one judge, it's a district court judge, so that's not binding precedent. And that case wasn't appealed, so we don't have an appellate court decision on that. But essentially, that is what the opinion said in that case.
My other question has to do with the level 1 and level 2 things. So the enforcement of, because there isn't a public notice and the enforcement of that, I wish Sheriff Cameron were here and could answer that around the practicality of enforcing those restrictions for level 1 and level 2. Is that something that we should be concerned about as well?
Yeah, and I think that's just a more practical question of enforceability. And I wish the sheriff were here too. I don't have a great answer because they're the ones that are going to be out there deciding who might be in violation of an ordinance, what level they might be. And beyond that, your city's prosecutor, which I believe is the county attorney's office, would also be more involved in that typically. But there were some other questions about enforceability that come to mind when you look at these ordinances. Bus stops is one thing. I mean, those change all the time. So I think the sheriff's department might have a difficult time, knowing where bus stops are. I think they change annually in a lot of cases. So, certain things like that are more practical, less legal. If that makes sense. But they are really important questions and important to talk to your sheriff about because people, I think, will want answers to those questions, and rightfully so. Those are really critical. Enforcement, what good is an ordinance if you can't, practically speaking, if you can't enforce it, or at least enforce it effectively? And so I think you're asking a great question.
Yeah. Councilmember Gunderson.
Is this something that could be addressed under the local controlled laws that are attempting to go through at the legislative level, where some legislators feel, to use an exact quote, local out of control, based on how we look, how we operate, do some of our zoning. This would be something for us, again, deeming who could live here. Would that fall under that quote of local out of control, saying who can live in the community no matter what pre-existing conditions are there? Or is this something you think would pass a legislative test that we would get the right to continue down whatever path we decide is best for our community?
I think that's more a question for the legislature to answer. I mean, I guess I've never heard the local out of control phrase.
I was said right out there, right in that chamber. But okay. That's a question that we have, because local control is something that, in this case, that we're talking about right now. We're talking about who can live in the community, how they can reside here. So for us to be able to have that and to be able to be effective in not only enforcement, but also when we get a notice 4 days before they're going to move here, how are we going to deal with this? And what tools are at our disposal to make sure we can deal with it effectively? So those are the things that I think I need answers to, so that we don't do something that, hey, it looks great on paper, we did something, but ultimately it's ineffective and is going to go nowhere, opens us up to other liability issues. And quite honestly, we can't afford $70,000, even if it is in insurance money, because that'll affect our bottom line. We're not the size of Apple Valley. So all these things come into play from where we're sitting. And that's where I'm at. It's frustrating, and I have a whole list of questions that'll come off as though I don't care. I have 3 kids that go to that school. I have 3 kids that live in this community. If this were my neighborhood, I'd be just as angry. But I've also had to ask myself this question: would a lot of people still feel this way if it were my neighborhood? My neighborhood has 6 kids. So there are a whole slew of questions that I have to ask, and that I've been asking myself for about a month now. And emotionally charged or not, we have to ask these questions to make sure that we're getting something that's effective, something that we can maintain, something we're not going to lose over time.
So that's where I'm at.
Mr. Anderson, another question for you around the restrictions. Has it been your experience, and we probably don't have a lot of case law to go by, but is it by being overly restrictive in terms of things like bus stops that might be difficult, level 1 or level 2, is it your experience that it certainly increases our risk, but have people taken advantage of that maybe for those more restrictive ordinances?
I haven't seen it in practice, but that doesn't mean it couldn't happen. I think it was said earlier, roughly 100 cities have adopted an ordinance like this, just shy of that. A handful have been challenged for various reasons, and frankly, I'm not sure if it's because they were more restrictive or if they were on the, stricter of the collection of ordinances, or if it's just because there was an individual who wanted to live in that city in a certain location that couldn't, and they found a lawyer to represent him. I'm not sure, but it could. It could mean that, if you effectively prevent somebody who is a sex offender from living anywhere in the community, I mean, that just on its face may not look quite as good, even though that could be argued from the other side that that's a protective ordinance that may have a lot of support. But practically speaking, I have not seen anything like that.
The other question that I have for you is, I think we're starting to understand that the Department of Corrections has a lot of leeway and a lot of flexibility in where they place these, regardless of what the local ordinance says. My concern, or my question for you is, we've kind of got two tracks going. We're trying to make some changes at the state level, along with strengthening our ordinance here in Victoria. If we're successful in making those changes at the state level, how does the ordinance that we put in place, how is that impacted by the state? So, for instance, if we are able to argue for preemption and say our ordinance trumps your state thing.
Well, yeah, I don't want to get hypothetical in terms of what changes you might see at the state, but for example, the state regulates liquor licenses in Section 3 in Chapter 340A. There's an express provision in that chapter that says cities, as the local liquor authority, can enact ordinances that are stricter than the state law. If you saw something like that in state law with regard to residency restrictions, it would take the preemption issue off the table. It would make it totally a non-issue, and you could effectively enact ordinances like this and not have to worry about that, because the legislature said, we don't intend this to be a field preemption by the state. We want cities to participate in this fashion. I don't know if that's even something the state the legislature is considering, but if they are, I mean, that would take care of it.
Okay. Council, other questions that come up here? I again want to express our gratitude to you folks who have done all of the great work and saved our city attorney time and quite frankly saved the city some money, because you've done a lot of the research up front, which we really appreciate. And I think right now we're just trying to kind of walk this fine line between what can we do to help protect our citizens and what can we, how can we keep ourselves protected from, frivolous lawsuits, if you will. So I think that's where we're headed. So council, I think at this point, and Ms. Hardy, tell me if I'm correct in this assumption, is I think generally we'd like to see all those changes adopted into an ordinance if it were constitutionally available to us. Is that fair to say?
Yes.
Council?
Yes.
Ms. Hardy, please.
Thank you, Mayor, members of the council. Thank you for that clarification. The one thing I'm going to add ask for some additional clarification because it was not appearing in the proposed amendments that our neighborhood has done, the committee has done for us here this evening, and that was some discussion, and I thought I saw head nods, 3 of you, about including some expanded language on vulnerable adults. And so I just want to circle back to council to see if I was hearing consensus correctly, and if that's the case, we will look at including language that would include vulnerable adults as well.
Fair enough.
Yes.
Yes.
Yes. And the adjacent. The adjacent.
Councilmember Black, Mayor, members of the council, I did not see consensus for that, but I.
Councilmember Black, will you?
Let me find it.
Will you remind us what you're looking for there?
Okay, when we were talking about designated level 3 predatory offenders, and it was a list of what was unlawful, they had 7, and I wanted to add, shall not be placed adjacent to the home of a minor or vulnerable adult. Meaning that if they are outside the 2,000 feet, they're at 2,001, and they plop themselves down and they're right next door to small children or somebody that's vulnerable, this would protect them from that. So basically the homes around, next or across the street, protects them from that.
Council thoughts?
I'm struggling with it because I agree with it, but I'm struggling with it because that could be any home in Victoria, just about. And it would be, I don't know, but it would have to go to the attorney and we'd have to have it vetted to make sure that that's something that would stand up and not be too restrictive, because that's, quite honestly, in Victoria, in some neighborhoods, that's every 5th house without children. And so.
Well, you said how many are in your neighborhood? 6?
Well, that's the only neighborhood in Victoria that has 6 children on 30 houses.
Well, that
Everything.
you know of.
I'm pretty
Well,
sure I
maybe
know
they
Victoria
just
pretty
don't
well.
belong here.
I understand, but we're trying to safeguard the city on multiple fronts with this. Not just from the offenders, but also from lawsuits that may stem from preventing them from living here.
So would that be too restrictive?
I can't opine about that on the spot. I'd want to think about that and look at some of the cases.
I think I saw it in Wisconsin in their state law statutes. I think that's where I saw it.
Yeah, my suggestion would be to direct staff to have that conversation. And if we work on an ordinance, to be brought back to the council to consider it and then provide feedback on it at that time.
Okay.
So do we need to, would we be able to okay this one and then add that to it? Or do we want to wait and add that and check that out first?
I think staff understands what the question is and can visit with the city attorney about adding that in.
I'm only hearing 2 of you saying yes, so I would be looking for at least one additional.
Yes, I mean, what I want is what's going to hold up.
Right.
So if we're looking at all options, yes, let's look at all options.
Yeah, let's take a look at it.
That's my only concern, is that I want to make sure what we do holds up. It's not that I'm against it.
Well, no, I understand.
I want that to be clear. I'm asking questions that are going to get asked.
Right.
And so I want to make sure it stands up. So if it.
Well, doesn't hurt to ask.
Right, and I appreciate that, but we have to make sure we're asking the questions. Is it something that time is going to, doing the research, is it going to give us the answer we want, or is it going to give us the answer we don't want?
Well, it's kind of the same thing as the question as to putting someone that's an alcoholic next to the bar,
I have issues
And they've
with.
done that.
I mean, I'll tell you, I am one. And so I'm able to control myself.
But not everybody can.
Well, I understand, but it's personal control and it's recovery and it's being given the opportunity to recover.
Yeah. well, growing up in Detroit, I saw a lot of people go into rehab and then come out and go right back to it.
Okay, I understand.
All right, so at this point, Sheriff Cameron, welcome. We were using your name in vain a little bit earlier, not seriously. We did.
The last 3-4 weeks?
No. We do have a question for you. So one of the considerations we are looking at for this ordinance is including level 1 and level 2 offenders as part of a restricted area. And the question came up about enforceability of level 1 and level 2 offenders, considering the fact that the public doesn't know who they are. You do, and your department does. But how effectively could you enforce that on level 1 and level 2?
Well, the offender has to register with our office, and so in another community where they have an ordinance, in all communities where they have published ordinances that we have access to, when the offender comes to register, we verify that that address would be in compliance with the city's ordinance. And then if it's not, then they're not allowed to register at that place.
So we could put that in our ordinances and, for instance, I don't have it right in front of me here, but
1,600 feet.
1,600 feet from a playground.
Or playground.
And if they're a level 1, it's 1,600 feet from a playground. If they register an address within that boundary, you can say no.
We could say that they would be out of compliance with the ordinance if they moved there.
Okay. Okay. And then the other thing that we talked about was bus stops and the ability to enforce that. Do you have, are you in communication with the school district about where bus stops are and that kind of thing?
No, what we have in another community that has bus stops included in their ordinance, they coordinate with the school and they produce a list or a map with circles around where the bus stops are. And so it would show, let's say you said it was 1,000 feet. So they'll have the bus stop with 1,000-foot diameter circle around it. And then it's overlaid on the city map so they would know. Because the offender has to do some research as well, right? And so with the bus stop identified, the city has already told the person here are the areas you can't be.
What if that changes in a year?
It requires maintenance, and that city maintains it.
So it's the onus is on the city to work with the school district and then to work with the school district about where those bus stops are going to be.
Yeah, because it is the city's ordinance.
Yeah.
Got it.
I didn't see the bus stop thing in here. That's not listed, is it? No, they didn't put bus stops in here.
Okay. I didn't include it. Okay. Yeah.
There is 2 bus stops within eyesight of that home.
Thank you.
Because of the density of children.
Thank you.
Sheriff, I do have a question. And if you don't have it now, it's not immediate, but is it possible to find out how many, in terms of number of sexually related crimes where it may have been a Victoria resident that's serving a sentence that may be released back into a home in Victoria, so that we would know, at least at some point, the potential for this to happen again from a Victorian resident? Does that make sense? In terms of the crime that happened here, if it happened here and it was a resident that may end up coming back to the community?
It would be a challenge to sort that out as the people who are incarcerated. I have no idea where they're going to be released.
I mean, would we be able to find out, because I know you have numbers for calls. And so if you are the arresting authority and that person's found guilty for the crime in Victoria, are we able to find that out in terms of the number of calls that you would get for a sexually related offense?
For sure. We can track the number of arrests for criminal sexual conduct in the city of Victoria. It gets to be a little bit more of a challenge to determine where the defendant resided at the time of the offense, and not all victims reside here. You
Yep.
might have a victim who resides in Chaska but goes to a licensed daycare here. Not saying licensed daycares have, but I mean, they're here visiting their friends because they're in the school. So that gets to be a little bit more of a challenge in that regard. Another thing that I think we need to be mindful of is that not all predatory offenders are sex offenders. And
Yep.
so
Fair enough. Yeah.
it'd be hard for me to ascertain where they're going to go to.
Thank you.
All right. Thank you. All right. Council, other questions, other thoughts? So I think at this point, I'd like to make a motion that we direct staff to develop an ordinance and schedule a workshop to further review
Final.
the options. Yep. And get the input from the city attorney. The other municipal ordinances, I know there's been a lot of work done on that already. Gather up the input from this hearing. Anything else? Are we okay with that motion? I know that was
You okay with that?
does that give staff enough information? So I'm going to make that motion. We're going to direct staff to draft an ordinance that takes into account what we've heard, what we've seen around the redlining, and the other options that we had in consultation with our city attorney.
And I assume the city attorney piece would include enforceability.
Yeah.
Again, because I agree with Derek in the sense that if you have something that looks great on paper, but it's not worth the paper it's written on, I don't want to be in that position.
All right, so we have a motion. Can I get a second?
Second.
All in favor?
Aye.
Aye. Any opposed? Motion carries. All right. One last thing here. Commissioner Paul Schnell has offered a seat on the Predatory Offender Working Group to the City of Victoria. We may want to consider appointing a council member, and I want to find out who from council might be interested in filling that role. So if you are interested in possibly serving on that, I kind of mentioned this double track where we're working on some things at the state level as well. If you would be interested in serving, raise your hand. All right, so we'll figure out who we will appoint to that. We'll figure out another way. I'll work with staff and we'll figure out how to appoint somebody to that committee.
Did we decide that we wanted it to be council or a member of the
I think there's an opportunity to do either. So
How about both?
Either, how about both?
I don't think there's two seats. There's one.
Okay.
There's one seat. Yes, sir, please approach. Could you please approach the podium and state your name and address for the record?
Eric Herbst, Woods Drive. Yeah, I think that'd be great to take an opportunity on. I would like our group to be able to put input on who we think would best serve our city on that.
All right, thank you.
Thank you.
Okay, so we'll work with staff and come up with some kind of a process to appoint somebody. We're going to have to, it's kind of a short timeline because the work is beginning, so we'll figure that out quickly. All right. With that, there is no other business to come before the council this evening. Can I have a motion to adjourn?
Motion to adjourn.
Second.
All in favor?
Aye.
Any opposed? Motion carries. Thank you. Thank you all. Good night.